Hello, my name is Leanne. I'm the Community Outreach and Volunteer Coordinator at Evenus, a domestic violence service that supports women and children experiencing domestic abuse through the stages of crisis, recovery and freedom. Our hope is to spread information and awareness around domestic abuse, its forms and impact, including the legal protection that exists to protect someone experiencing domestic violence and coercive control. Domestic abuse is an incident or pattern of incidents of controlling, coercive, threatening, degrading or violent behaviour by a partner, ex-partner, a family member or carer. Domestic abuse can include, but is not limited to, the following: coercive control, psychological and or emotional abuse, physical or sexual abuse, financial or economic abuse, harassment and stalking, online or digital abuse. It's important to know that domestic abuse is a crime. Under the domestic violence legislation, you can apply to court for orders to protect the welfare or safety of the person making the order, also referred to as the applicant, and if applicable, their dependent children. Court orders are made by a judge and come with specific instructions or directions. Some orders direct the person accused of abusive behaviour, also referred to as the respondent, to stop committing further acts or threats of violent behaviour. Others direct that person to leave and stay away from you and your children and the home. You will need to explain to the judge in court why you're asking for a specific order. Most applications for domestic violence orders are made in the district court. However, some are made in the circuit court or high court. I'm going to provide a brief overview of orders available in the short and longer term. If you need immediate protection, you can apply for a protection order. This is a temporary safety order granted by a court when a person applies for a safety order and or barring order. A protection order prohibits a person from using or threatening violence towards the person who has been granted the order and or any dependent children, and lasts until the full court hearing of the application for a safety order and or barring order. You do not need to be living with the person or have lived with them in the past to apply for a protection order. An interim barring order is a temporary barring order. It's made in exceptional circumstances as it's granted without notice to the person against whom it is made. The court grants this order when they form a view that there are reasonable grounds for believing that there is an immediate risk of significant harm to the person seeking protection or any dependent person. An interim order can last for no more than 8 days. However, further orders may be made until the full hearing of the case. An emergency barring order is available in certain circumstances to people living together and parents of adult children who would not be ordinarily able to apply for a interim barring order because they may have lesser ownership rights in the place of residence than the person against whom the order is being sought. It can be granted without the notice to the person against whom it's made and can last for no longer than 8 days. If you obtain interim protection, you will also get a hearing date for a safety and or barring order. A safety order prohibits a person from using or threatening violence towards the person who has been granted the order and or any dependent children. A safety order does not require a person to leave the home they share with the person who has been granted the order. You also do not need to be living with the person or persons you are seeking protection from. A safety order lasts for up to 5 years. A barring order directs the person whom protection was being sought against to leave or stay away from your home and any dependent children. In some cases, it can direct them to stop using or threatening to use violence and putting you in fear. It may also direct them to stop following you or communicating with you or your dependent children. It requires the person against whom the order is made to leave and stay away from your home. It lasts up to 3 years. Violent acts or threats can be made by someone who is related to you by blood or adoption, such as parents, adult sons and daughters, and grandparents. They can also be made by people the court considers an intimate partner. These include current and former spouses, civil partners, cohabiting partners, and your child's other parent, and unmarried intimate partners. A breach of any order made under the domestic violence legislation is a criminal offence. The Gardaí can arrest and charge a person who breaches such an order. For Gardaí assistance, call 999 or 112. At Evenus we have a court preparation and accompaniment service whereby we can offer you support in the following areas: information on legal orders, court process, court application process, court accompaniment, court preparation, assistance in legal aid application and gathering necessary and applicable documents, linkage and advocacy with the Gardaí, solicitors, barristers, social workers, legal personnel, and support after court. At Evenus we have a dedicated court preparation and accompaniment service. If you require support or information, contact our team today.
If you need immediate help or support, please contact our 24-hour free phone helpline on 1800 767 767. If you would like to learn more about our court preparation and accompaniment service, please check out our website evenus.ie or contact us on 01912 1670. This video has been made possible through funding provided by Crime Victim Support, Department of Justice.